15 seconds, 10 seconds, 5 seconds. The appellant is the wife of first respondent. The respondent husband has filed a petition under Section 13 of the Hindu Marriage Act 1955 before the Court of Learned District Judge Ludhiana, seeking dissolution of the marriage by grant of a decree for divorce on the grounds of alleged adultery and cruelty. There is no dispute over the fact that out of the lawful wedlock, the appellant has given birth to 3 daughters and one. There is another son who is also living with the appellant wife. The respondent husband would raise doubts about the details of percentage of the said child, having regard to the fact that a limited notice has been issued. In this case, it is necessary to deal with the details with reference to the claims made by the respective parties about the details of income of either of the parties. Notice is confined to the question with regard to the order for conducting a DNA test of the child. The learned counsel for the appellant strenuously contended that the conduct of the parties requires to be adjudicated, and it has no relevance at the stage of granting interim or pendant maintenance, and that the consideration in this regard has to be confined to the criteria specified in Section 24 of the Hindu Marriage Act 1955. It was also pointed out that imposition of a condition will operate to deprive the very maintenance order to be paid. The conduct of DNA test of the male child in question is not warranted in this case. The limitations to be observed in compelling any person to give a sample of blood against his or her will for DNA analysis is the branding of a child as a bastard and the mother as an unchaste woman. It was made clear that no adverse inference can be drawn against the person for his refusal. Such an order could not and ought not to have been made at this stage. In the matter, the law is governing the consideration and passing of any order in respect of a claim for DNA test. If a party to a proceeding cannot be compelled against his or her wish to undergo any such test, we fail to see that how the court on its own could have imposed a condition without any consideration of any of the criteria laid down by this court and whatsoever it is. Stop. Over.